property because it should be understood as an extension of you. It's like by virtue of it being creative expression, it's like part of you as an individual, your personality, whatever. That especially maybe makes sense in the context of things like copyright or whatever, where we're talking about is art rather than a patent thing where we're talking about like an invention you produced. But we'll write that. For now, suffice to say it again, that is not the purpose for USA provisions. Okay. So the first area I want to start off by talking about is patent law. I think that before we dive into that, we need to kind of briefly talk about the structure of the US legal system. I'm going to keep this pretty cursory. If any of this is confusing or you have follow-up questions about it, please feel free to jump in, because it's much better for us to resolve that up front before getting into some of the details of these laws and how they're applied. That being said, I also suspect that for some of you, you'll think it is clear, and then when we talk about particular applied examples, it'll maybe become a little bit more muddy, in which case, please feel free to jump in at that stage as well. Don't feel like a ship has sailed on this. Okay. Very quick, kind of like top-level survey of things. The U.S. Constitution exists, right? Everyone's on the same page about that, I hope. Separately, so the Constitution provides its own sort of legal, its own basis for legal decisions, right? One could, like the courts frequently will issue constitutional rulings where they are interpreting constitutional provisions to decide that a thing is okay or not okay. Separately, you have statutes, which are what Congress passes, right? And once Congress passes a given law, that provides sort of a legal basis for a set of actions to be taken. But Congress itself does not execute, implement, or interpret those laws. They simply make those laws initially. The job of the executive branch is then to implement those laws, which sometimes Congress will speak really clearly in a given statutory regime. And so the executive branch just needs to like go do the thing. Often though, even if you were to write a bill that's like 900 pages or whatever, that can't possibly account for all of the implementation details that are necessary when the rubber meets the road. And there's also a whole debate to be had here about like whether it's even desirable for Congress, who fundamentally is not an expert in any of these fields, to try to kind of like be overly specific about any of that. So in practice, the way that this usually works out is Congress will pass a law that might be more or less convoluted or specific. And then the executive branch will engage in the task of interpreting the provisions of that law and promulgating rules and regulations that explain to the regulated public how they interpret and understand those different provisions in more detail, right? So you have your patent experts in the executive branch who are like, Congress says this set of like top level stuff about patents. Here, concretely, is what we think that means. Here are the exact rules we think you need to follow. Here's how we're going to go about implementing it. Yeah, does that make sense? Courts will then often, if somebody thinks that that set of executive interpretations are, out of alignment with the statute that Congress has passed, then they can bring a lawsuit about that. The court will adjudicate that question and decide, was this a reasonable interpretation of that law or not? There are a whole kind of separate set of legal and doctrinal questions that one could grapple with here that I'm going to entirely kick the can on / put a pin in, because I don't think they directly bear on any of what y'all will be debating right off the bat. We may come back to this down the road later in camp if folks have questions about it. But long story short, courts will then review that set of executive interpretations and associated enforcement actions. We call that judicial review. Sometimes, either because the court believes that, without getting too deep into the reasons why, sometimes courts will themselves step into the task of figuring out what the provisions of given statute mean, rather than leaving that up to the executive branch. And so when people talk about judicial interpretation of statutes and regulations and stuff, that's what they mean. Okay. So again, to survey so far, we have the Constitution. Courts will interpret it and apply it. We have statutes that must be constitutional, right, in order to pass judicial muster. The executive branch, or sometimes the courts, will interpret that set of statutes and stuff. The executive branch is charged with implementing those things. We then have this other little bucket called common law. Does anybody know what common law is? Yes.
It's a Commonwealth law. It's like a leftover from a proclamation in England, and holdover just general stuff basic laws that are pretty universal and previous.
Yeah, that's exactly right. When you say basic laws, what do you mean?
No murder, no stealing.
When you say laws, what do you mean?
Instructions for how, for what the government can intervene.
Sort of. Yeah. So that was great. Broadly, that's spot on. So whereas, like I said a minute ago, we have the Constitution, we have statutes here. Generally, the way that the U.S. legal system is sort of kind of traditionally taught in an initial social studies class or whatever. It's Congress makes the laws, courts interpret them, executive implements them. As we've kind of already gotten into, it's a little bit more complicated than that. The common law in particular is a sense in which that isn't really an accurate or complete characterization of what's going on. Because when we say law here, we are not talking about laws that Congress has passed. Instead, what was your name?
Kit.
Kit. So instead, like Kit said, there's a kind of broader body of judicially created law that has its roots in the British legal system and was sort of imported into the U.S. legal system at the founding, that governs all kinds of things related to, the way that the court does their job, the way that without getting too deep into the contours of this, the short version is there are things that are not statutory where the court is this is our job to figure out, and everyone broadly agrees that it's the court's job to figure out. And so the court engages in adjudication based on common law principles, i.e., here is the way that courts have evaluated this thing for hundreds of years. We're going to continue to, broadly speaking, apply this set of longstanding legal principles, especially absent Congress stepping in and being we think that this should change now. Here's a statute. Does that make sense? Here in a minute, we're going to talk about the statutory regime that has been set up for patents. An easy way to understand this common law premise, if this is a little bit muddy, is imagine that we only had, we have this top-level constitutional command that the Congress had the authority to establish this set of intellectual property protections and to promote the progress of the arts and sciences or whatever. That's pretty big. And the court can engage in some interpretation and be here's what we think useful arts are. That still doesn't answer any questions at all about how patents should work. How long should they last? How should they be protected? Whatever. And so one could imagine if counterfactually we did not have this set of statutes, and yet we needed to adjudicate some of these intellectual property concerns. How would the court handle that? And the answer is common law. They would be well, here stretching back to even prior to founding are the sorts of principles we cared about for intellectual property, for example, utilitarian theory rather than Lockean theory. Therefore, here's how we think we're going to muddle our way through this until one of the other branches does something. Okay. To further complicate this a little bit, or at least add an additional kind of complexifying element. Litigation is when you're bringing a suit in Article 3 courts. Article 3 of the Constitution being the article of the Constitution that establishes that there is a Supreme Court / a federal judiciary, and that has the power to, quote unquote, hear cases and controversies. Sometimes, though, one of the organizations we're going to talk about here in a minute, the U.S. Patent and Trademark Office, is the primary executive branch agency that oversees patents and trademarks and stuff. And they have their own kind of internal patent adjudication body. And so often kind of the first stop for challenges to a given patent or whatever will not be, I'm going to go straight to court, but rather I'm going to go to this separate sort of pseudo court that has been set up for purposes of hearing this set of patent-related disputes because it's staffed with experts in patent law and stuff who are very familiar with all the rules, know what else has been patented, are able to therefore kind of speak to all the technical questions involved. But if one were then thought that the process that they underwent there violated their rights in some way, or again was like out of alignment with the legal rules and requirements that Congress has laid out or whatever, then they could challenge that resultant set of decisions in the courts. Does that make sense? So ultimately, your kind of forum of last resort is always going to be the US federal judiciary, at least in the context of something like patents or trademarks or whatever. But sometimes there may be other sort of not actually judicial processes, but like sort of pseudo-judicial processes that like Congress has set up or that the executive branch has set up as sort of a first stop along the way. And the majority of these sorts of issues actually get resolved at that stage. It's only really when you think like that when you've been like very seriously aggrieved or you feel like you have a really strong case to like get some major rule changed or something that you will take it to court. Does that make sense? Part of the reason that's important to understand is because I do think that there's a decent chance, like certainly some acts this year will be about kind of sweeping statutory or judicial reforms to IP protections. But I do think that there will be a significant chunk of them, and we'll talk about this more when we do the like diagram to resolution, talk about specific examples part of this lecture later. But I think that there will be a significant chunk of them that instead do things like change the rules that are applied by some of those other kind of executive and congressional bodies. So we'll get into the weeds on that more later, but I wanted to tee that up a little bit. Questions about any of this so far?
When is like common law?
This is a little bit reductive, but for purposes of this conversation, I think it suffices to say whenever the question is not adequately dealt with by other sources of law. So when there is a gap left by constitutional interpretation, statutory interpretation, executive interpretation, and enforcement actions, et cetera, and the court is called upon to resolve some dispute that is properly in front of them, and they don't have the tools to do that using these other things, the idea is like, then they draw on this long legal tradition of judge-created law, aka common law, to resolve it. Does that make sense? Yeah.
I just thought it was also worth mentioning that that's kind of in contrast to like a civil law system,
Yeah.
which is like strict adherence to written code. So that's kind of the way you can think about it. It's more like interpretation and tradition than like this is the letter of the law and we're going to go by that.
Yeah, exactly. France, for example, has a civil law system. And so if you're interested or want to kind of further, that's a really good point, if you want to sort of like to further kind of concretize what we mean when we talk about a common law system, going on Wikipedia later or whatever and looking up like civil law systems or whatever and like understanding it kind of by contrast, I think is helpful. Yeah.
Is common law like the same thing as case law, or like those are like citing old cases?
No, sort of the squares rectangles situation, because case law just refers to the idea that the court has in the past issued rulings that they're on a given issue. But that could be at the level of we've previously interpreted the statute to mean this thing or whatever.
Okay.
Alternatively, it could be courts have traditionally resolved this issue in this way, in which case it's like a common law example of that.
Okay.
Does that make sense? Yeah. Anything else? Okay, patents. First, like we talked about a few times, Constitution says that